Under section 124, official communications. This section is designed to prevent the knowledge of official papers, that is to say, papers in official custody, beyond that circle which would obtain knowledge of them in confidence, whether the confidence was express or implied. It would normally include all officers, including clerks of superior officers, and might also apply to non-officials to whom such papers were disclosed, on understanding, express or implied, that the knowledge should go no further. Public interests are paramount as compared with individual interests of a party in a court of justice. It is absolutely essential to the welfare of the state that the name of the parties who impose in situation of this kind should not be divulged, for otherwise, be it from fear or shame, or the dislike of being publicly mixed up in injuries of this nature, few men would choose to assume the disagreeable part of giving or receiving information respecting offences and consequences would be that many great crimes would pass unpunished. There is a privilege which attaches under certain circumstances to communications made to public officers. State secrets are matters which govern the administration of a government should not be disclosed, since to reveal them might be highly prejudicial to the public interest. Therefore, communication relating to affairs of a state are generally held to be privileged, and the officers may refuse to disclose them. Public officer cannot be compelled to disclose communication made to him in confidence if he consider that public interest would suffer by this disclosure. This section confined to public officers. Section 123 embraces everyone. Section 123 deals with unpublished records. This section deals with communications made in official confidence. A party in a civil suit sought production of income tax return of the opposite party. The court refused to summon the document as per considering it to be privileged document. This was held to be not justified. It was up to the Commissioner of Income Tax to claim privilege when document has been summoned. It is then for a court to decide whether a privilege is to be granted or not. Under section 125, information as to commission of offences. On a ground of public policy, a magistrate or a police officer cannot be compelled to give the source of information received by him as to the commission of offences. Similarly, a revenue officer cannot be compelled to say, hence, he got information as to any offence against the public revenue. Such officer may, if he likes, disclose the name of the informant. It is of importance to the public for the detection of a crime that those persons who are the channels by means of which the detection is made should not be unnecessarily disclosed. The accused is not entitled to elicit from individual prosecution. The accused is not entitled to elicit from individual prosecution witnesses whether he was a spy or an informer, or discover from a police officials the name of the person from whom they had received information. But detectives cannot refuse on a ground of public policy to answer a question as to where he was secreted. Although this section does not in an express term prohibit a witness, if he be willing, from saying when he got this information. The protection afforded by this section does not depend upon a claim of privilege being made, but it is the duty of the court, apart from objection taken, to exclude such evidence. If objection taken, it cannot, since the law allows, be made the ground of adverse inference against the witnesses. If the application of this privilege, the criminal procedure has to be accommodated two goals which are at the time at odds with each other. On the one hand, it has to afford accused person an adequate opportunity to establish their innocence. An accused must have uninhibited right to challenge the evidence against him and establish innocence. On the other hand, the criminal procedure has to be promote the detection of crime. This accommodating process was in evidence in R versus Johnson. The charge against the accused was supplying controlled drugs. The evidence against him consisted of a testimony of police officers who secretly observed the accused from premises belonging to private residence, who agreed to provide the police with observations post. The prosecution was granted permission to withhold any information which could lead to the identification of these premises. As a result, the counsel of the accused was not allowed to cross-examine the officers, but the location of their observation post and of the nature of any observation to their view, the prosecution relied on public interest immunity as justifying the withholding of information about the observations post. It is well established that the police may suppress the identity of informants in the interest of combating crime. It was therefore held that within the scope of this principle, the secrecy of observation post could be maintained. It was an important to secure public cooperation in providing suitable observation posts, as it is to encourage the public to come forward with information. However, it is necessary for the claim for immunity to be entertained that the owners of the premises should object to being identified. Under section 126, professional communications. Now this section is based upon the principle that if communication to a legal advisor were not privileged, a man would be deterred from fully disclosing his case so as to obtain proper professional aid in a matter in which he is likely to be thrown into litigation. Under this section, no barrister, pleader or vakil shall at any time be permitted to disclose any communication made to him by or on behalf of his client, or any advice given by him to his client in the course and for the purpose of his employment. To state the content or conditions of any document with which he has become acquainted in a course and for the purpose of his employment. The privilege also extends to documents prepared in connection with the client's claim for the dominant purpose of preparing for litigation. The section does not protect from a disclosure any communication made in furtherance of any illegal purpose. Any fact observed in the course of employment showing that any crime or a fraud has been committed since the commencement of the employment. Under the section 127, the above provisions apply to interpreters and the clerks or a servant our barristers, pleaders, our attorneys and vakils. The section not only protects the legal advisor from disclosing communications made to him by his client when interrogated as a witness, but he is not permitted to do so even if he is willing to give evidence unless with the express consent of his client. The privilege under this section is not absolute. When defamatory questions are put by a lawyer to a witness in a cross-examination on a client instructions without any reasonable basis for putting them, such communication is not a professional and its disclosure is not protected under this section. Section 126 to 129 deal with the privileges that is attached to professional communication between the legal advisor and the client. Section 126 and 128 mention the circumstances under which legal advisor can give evidence of such professional communications. Section 127 provides that interpreters, the clerks or a servant of legal advisors are restrained. Similarly, Section 129 says that when a legal advisor can be compelled to disclose the confidential communication which has taken place between him and his client, the law officers have been held to be within the scope of the section. The communication between an insurer and his counsel are also privileged. Notes made by the lawyer of a statement of a witness are within the range of protection. In the case of Gangaram versus Habibullah, 1935, 58 Allahabad 364, it was held that protection afforded under this section cannot be availed of against an order to produce a document under section 91 of the Code of Criminal Procedure. The document must be produced and then under section 162 of this act, it will be for the court after inspection of the document, if it deem fit, to consider and decide any objections regarding their production or admissibility.